In the amended indictment has Gonzales.
Okay, in the amended, so maybe we're just looking at this. Okay, so then that should be fine. Other than that, we'd be looking for the concurrent causation.
Do you have a proposed?
I think we're working on the language right now. Let's see. Yes, we can get on the record.
Which judicial district are we filed in? Here. What number? Okay. How long are we talking? Argument request?
I mean, it's, there's just, yeah, I mean, we have over 1,000 exhibits. We have weeks of testimony. 2 hours?
Yeah. You think you can hold their attention for 2 hours on each side? Long time.
I think we've shown that we can do that.
Well, are we splitting time?
Nico and I will be splitting, yes.
Splitting time?
Yes, sir. And we'll get that called out.
And Judge, if we don't need it, then we won't take it.
Let's go an hour and a half. If you go a little bit over, I won't hold it against you, but let's see if we can shoot for an hour and a half. That's going to be 3 hours with them sitting in the box. It's a long time.
Yes, Your Honor. We would ask for maybe if an hour and a half has gone by and they're still sitting there, if they could have a break. I don't know how long the state's going to go on their front end. But
Well, I mean, we got opening and then we got yours. So yeah, it's going to be a little bit difficult to, take a break in there without
understood.
giving one side or the other the advantage.
We understand that.
And if y'all want time warnings, give it to me in writing. So Christina.
Oh, Judge, we also would like not guilty to be first on the verdict forms. Like, if
Would you do me a favor? Not a biggie. Can you give me this? Pronunciation. Okay, we'll do the not guilty first. That's typically the way it is in most charges. That's fairly standard.
Uvalde, we go guilty first, so. Anyway,
Well, I mean, on the pattern jury charges,
yeah.
they do the NG first. I was on that committee for a long time, and finally I was released. The meetings were like watching paint dry. Okay, so he's tracking the corrections we've made so far.
Where do you want,
Okay.
where do you want that causation application?
You have an idea? I mean, there's a, it looks like there's a stipulation, and then there's instructions on count 2 through 29.
And before I forget, y'all need to tell the reporter what was demonstrative and what goes back.
Yes.
So make sure she knows which were demonstrative only and which go back with the jury.
Yes, yes, sir. We plan on trying to go through that today.
And I don't know, what do they do in Uvalde as far as sending it back or requesting?
You talking about all the exhibits, or demonstrative?
No, I'm saying, does the judge in Uvalde send the exhibits back with the jury, or do they want them to request?
She sends them all back usually. How about right before the instructions on count 1 on page 4?
Yes. I think that's okay.
Yeah, sounds good.
We're also going to ask a requirement of voluntary omission charge under 601 of the penal code, which a person commits an offense only if he voluntarily engages in conduct including an act or omission.
Okay, well, we'll get on the record here on those issues.
Just for trying to figure out where it fits, if it does.
let's go ahead and get on the record here when you get a chance. I know you're still organizing, but we can see where we are on contested issues, if any. All right, so we're outside the presence of the jury. Both sides have rested and closed. The evidence in the case, and we're in the charge conference, we've already agreed on several changes to the charge as proposed, but you had some request, causation, and the instruction on the omission.
Yes, Your Honor, and I think I'd like to start with, I know I did this in the motion for directed verdict, but I'd like to start by making our objection clear to the court that there is no duty under Luther v. Texas Parks and Wildlife 605, 606 of the Code of Criminal Procedure and the Texas Education Code 387.081 does not establish any duty for a police officer to act in this way and in the way that the prosecution has done that. So because it does appear in the charge, we are lodging our objection to that appearing in the charge because there is not a duty and it's not established, and that's, we just say it's our argument is that it's an improper statement of the law and incorrect.
All right, State.
Your Honor, this was thoroughly briefed in the concurrent case about duty to act and whether the civil law controls the criminal code. We believe it's two completely different things. In fact, the Supreme Court leading case on it says the state can always impose an obligation that the civil law does not. Basically, they're talking about whether or not a victim has the right to recover monetary damages based on the duty to act. But those cases hold specifically that the courts have allowed or provided the state can provide that it's a criminal offense.
Okay, objections noted, overruled. It'll be submitted as charged in the proposed charge.
Yes, Your Honor. The next thing is the concurrent causation instruction. The instruction would read, a person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. So that would be the language that we'd ask the court to instruct on. You know, what we raised in this case is that there was a shooter who committed the act. We believe the shooter could be potentially a concurrent cause. That it would have happened, you know, it would clearly produce a result regardless of where our client was. Additionally, the locks and the condition of the school is a concurrent cause as far as without the locking issues and mechanisms, and it had the door been locked, there would be a concurrent, that it would also be concurrent causation. The shooter would not have been able to access the school, and therefore the door being unlocked is clearly sufficient along with the shooter to produce the result. So we believe there's evidence contained within the record that would justify a concurrent causation instruction.
Any objection, State?
No, Your Honor.
All right, it'll be the request for that instruction will be granted. No objection. Where do you want it included in the charge? Where?
Yes, Your Honor. I think that we've decided that at the right after the defendant's decision not to testify, and then the words instructions on count one, that there be a paragraph including the concurrent causation language.
Okay, that'll be granted.
The final issue is that under the Penal Code 601A, it just says a person commits an offense only if he voluntarily engages in conduct, including an act or omission. So there's a requirement that it has to be a voluntary omission and that they would have to prove that. Well, I guess I'll let you guys do it.
State?
The only thing we noticed was ask them to identify any information that this was not a voluntary act.
Yes, Your Honor, we would. Okay, so from the statements made by that Mr. Gonzales himself, that the state introduced into evidence, that he was not aware of what was happening, of what was going on. And so if he's not aware of where something is or
Objection.
whatever that is,
Okay. All right, I think it's raised, so that'll be granted. It'll be included.
and as to where to put that, I'm looking at that, and I don't know if it necessarily fits, but there is some definitions, and there's conduct on page 5. There's the definitions of conduct and the definition of omission. It could perhaps go after that, because that's, I think, where it's
I think in between omission and intentional conduct, maybe?
Yes, Your Honor. It's, it's not technically a definition, but it kind of is. It's explaining the definition of omission.
Yeah, let's put it right after omission then. Okay, if we don't, state have any other requests or objections?
No, Your Honor.
All right. Let me ask the lawyers to be here at 8:30 so we could review the final charge prior to the jury coming in at 9 to see if we have any further issues. And it'll be an hour and a half to each side. Again, if additional time is requested, we'll consider it either side. But if you want time warnings, it's up to you. Tell me what you want in writing before y'all start arguing, please.
Yes, sir.
Okay, we'll be in recess for the day. We'll see the lawyers at 8:30. Thank you. Court's in recess.
Okay, so Juan, we've been watching this charge conference. Talk to me about, explain to people what this is and why this was happening.
The charge conference is just a meeting between the lawyers where they prepare the instructions that are given to the jury. These are written instructions that set out the law and what the state must prove, and any defenses are defined in there, or any terms that need to be defined are in there in the instructions. And these are documents and instructions that the jury takes with them. They're read to them in court, then they take them back into the jury room, and they refer to them when deciding how to vote, how to come up with a verdict. So if the jurors are back there and say, well, what is the law? How do we apply it in this case? The instructions are in there. And they're very important because each side, of course, lobbies to have something favorable in there. The defense always asks for things that sometimes shouldn't be in there, or the judge is not going to let it in. But you ask for it, and then if it gets overruled, then you can appeal it later if it doesn't go your way. But these are just the instructions that the jury receives, and usually the judge wants input from both sides before they decide what to put in it. And that's what happened here. That's why they asked each side, is there anything you want in there? And he let some things in for the defense that they wanted, and the state didn't ask for anything, but he overruled them on another matter.
Well, he did want, the defense wanted to strike the part about the duty to act.
Okay, exactly. So, but
What'd you think of that?
I mean, I expect them to.
You expected that to get overruled.
I expected that. I expect to be overruled too, but it's a pretty straightforward charge, I'm sure.
And those are kind of the things you have to do anyway for appeals.
Exactly.
If this ends up being a conviction and you have to appeal. And then the other thing they wanted was the part about the concurrent
Causation.
Talk to us about that and what that means.
You don't see that a lot in cases, but you do see them in cases where you're charging somebody with a crime of omission, this is what this is, and they want an instruction in there to say if there's a concurrent cause that caused the death or these children to be hurt or endangered, you can take that into consideration and whether it would have happened anyways, even if he didn't act the way you thought he should have acted.
Right, such as the shooter.
Exactly, the shooter and the locks.
And the locks, right. That makes sense. Okay. And so
and I might say that even if that's not in the charge, in the instructions, the lawyers can still argue it anyways.
I mean, it feels like no matter how this jury decides things, that those will be things they would take into account.
Correct.
That makes sense to me. And the defense had asked for 2 hours for closings, and the judge said, hour and a half apiece.
Lawyers, we always ask for more time than we actually get. We ask for 2, knowing we're going to get an hour and a half. So I think that's for a trial this long, an hour and a half makes sense. They said there was 1,000 pieces of evidence that were introduced, so they want to have the opportunity to go over some of those, and they don't want to run out of time. And usually the judge puts a limit for each side, but if he said you've reached your the limit of your time. If they ask for like 5 more minutes, usually the judge will give it on an important case like this.
Right. But it's still a long time.
It's a long time, and they will use it all.
Well,
they will
yeah.
use it all. Us
Lawyers do like to
lawyers,
talk.
We like to talk.
Well, and then the other thing that I thought was interesting, you were telling us while we were watching this, that just reading the jury charge probably will take a half an hour.
Exactly, because they got to read the whole charge for each count.
They
So
can't like say, oh, well, 1 through 29. It's
Yeah,
got to be
exactly.
every single
They got
charge.
to read it all into the
Wow.
record.
So that could be quite some time, because we have, obviously the 19 charges related to the children that died, and the 10 for the children that were injured.
Correct.
And then in the morning they said it sounded like they would be back briefly,
Yes.
just to say, yes, we're good with this jury charge.
Exactly, because what's going to happen, they're going to add all the everything they talked about here today, and they're going to make a final jury charge that they'll hand out to the lawyers in the morning. They'll look it through again, because sometimes even after that we find mistakes or something wasn't put in the place we wanted to be put, and so he wants to make sure that's the final draft, because once you say that's it, they're going to read it to the jury.
Right, and they were checking spellings.
Yes.
I heard them,
Yes.
fixing some spellings and that sort of thing. Okay, well, Juan, thank you we thought we were done, and then I got a text message from one of the producers down there who let me know that no, we were not done, and the judge, they were going to be doing this charge conference. Well, thank you for watching our coverage of the gavel-to-gavel coverage of the trial for former Uvalde school police officer Adrian Gonzales. Again, if you missed any of the testimony or analysis from throughout the proceedings, you can go back and get caught up on our YouTube page or right here on our Plus app. We'll be back tomorrow morning. Our coverage will start around 8:30 a.m., maybe a little bit before that, since we're waiting to see exactly what time the court actually begins with this short jury charge. And Juan, thank you so much again.
Thank you for having me. It's
Again,
been a
Juan
pleasure.
Sanchez, thank you so much for joining us today, and we will see you tomorrow morning.